many of you do know me, but many of you don't. So I'll give you a little bit of a background here. I'm an attorney, Karen Orlin, licensed in New York since 1973 and in Florida since 1982. I have over 50 years experience as an attorney with law firms in New York and Florida and in-house counsel to financial institutions in Florida. I organized a Florida state chartered bank when I was practicing there. I concentrated my law practice on mergers and acquisitions, securities offerings and regulatory compliance, commercial lending and other business transactions, and bank holding company and bank regulation, mostly federal. Since 2011, I've been an arbitrator for the Financial Industry Regulatory Authority, FINRA. I've been chair qualified on that platform since fall of 2022. Since 2021, I've been an arbitrator for the American Arbitration Association for commercial and consumer cases. Since 2006, as Linda mentioned, I've been an expert witness in attorneys' ethical and fiduciary duties and standard of care and loyalty, mostly in legal malpractice cases across the United States. And I've been a very active member, continue to be an active member of ethics and professionalism committees of various bar associations in New York and Florida, as well as, of course, at the ABA level. I have been a member of the ABA since 1973, when I first started practicing after passing the bar in New York. And from 2022 to 25, I was vice chair and then chair of this ADR committee. Since spring of 2025, I've been chair of the Senior Lawyers Division Ethics and Professionalism Committee, and I'm currently a candidate for the ABA Standing Committee on Professional Regulation. So if lobbying does any good there, or you know anybody that can help me get on that committee, I really appreciate your help. So moving into the substance of my talk, we're going to be talking about ethics rules applicable to lawyers who serve as arbitrators, not rules applicable to lawyers representing parties in ADR proceedings, because there are many that apply only to people in that role. We're also not going to be talking about mediation because I don't have any expertise in mediation. So I'm limiting my discussion to lawyer arbitrators. This includes some information, but it's not identical to the information that I presented in a meeting of this committee on February 26, 2025. That presentation recording of it is posted on the webpage of this committee if you want to go back and look at that at some point. Relevant rules that we're going to be talking about today have not changed since then. Although some of the AAA presentations have changed. The context of this discussion of arbitrator lawyers and the higher standard that they're held to, or different standards that they're held to in some cases, is that a binding arbitration is considered to be a tribunal, just as a court is, for the purposes of the ABA model rules of professional conduct. The model rules do not govern anyone technically. They're not regulations of particular states. They're not statutes. They're not laws of any kind, but they are the basis of the rules of professional conduct that have been adopted by courts or agencies regulating lawyers licensed to practice law in most states of the United States. Now I'm going to just recite for you, some of these, and you might want to make note of some of these. Some of them you may be familiar with, some of them you may never have heard of before, that are the authorities for the rules of ethics that apply to lawyer arbitrators. Some of them apply to arbitrators whether or not they're lawyers. The Code of Ethics for Arbitrators in Commercial Disputes, effective March 1, 2004, was originally prepared in 1977 by a joint committee consisting of a special committee of AAA and a special committee of the ABA. It was revised in 2003 by an ABA task force and a special committee of the AAA. It's intended to apply to all commercial arbitration cases on any platform that has adopted it. That includes FINRA, under FINRA's Arbitration Guide, Part 3, the arbitrator's role, ethical considerations. So that was last revised in April 2023. It's arbitration cases proceeding under any of AAA's rules. And those of you who are arbitrators or mediators for AAA know that there are different rules for different types of cases. And it also, that code of ethics also applies to all persons deciding cases in the role of an arbitrator, whether denominated arbitrator, umpire, referee, neutral, or otherwise. Not technically to mediators. Mediators have their own set of rules. However, there's an exception. Cases that are conducted under AAA's Code of Professional Responsibility for Arbitrators of Labor Management Disputes and certain domestic arbitrations in which the objectives of neutrality, independence, and impartiality may not apply, uh, are not subject to these code of ethics rules, and accept that agreements of the parties and rules of professional conduct and laws in effect in individual states may be applicable to particular cases and circumstances, and they may have requirements that differ from the code of ethics requirements. So whenever we know that whenever we're doing an arbitration, and it's true for mediation too, I assume, you always want to take a look at the detail at the underlying agreements that give the platform the jurisdiction for that proceeding, because that may have additional requirements that you might not otherwise have had experience with. It may be particular to that case. There's also the second authority for these rules of ethics are the standards and responsibilities for members of the AAA ICDR roster of arbitrators and mediators. That was last revised in August 2025, and that applies to all AAA ICDR roster arbitrators and mediators, regardless whether they're doing commercial or consumer or labor or construction. Doesn't matter the type of case. AAA's commercial arbitration rules and mediation procedures, as amended and effective September 1, 2022, apply to all AAA roster arbitrators and mediators that are practicing in the area of the commercial arbitration wing of the AAA. And as I mentioned, they're not the only rules that the AAA has promulgated. There's also AAA's billing expectations for members of AAA and ICDR. There's a form, there's a leaflet, if you will, that sets forth very specific requirements for billing if you're an arbitrator for AAA. The notice of compensation arrangements for the respective AAA arbitration case, and every arbitrator that's assigned to a AAA case, regardless of the nature of the case, will receive at the time of the appointment as an arbitrator a copy of the notice of compensation arrangements that will state specifically how compensation is determined for that particular case for that arbiter. Might be hourly rate as it is currently for consumer cases. It might be a fixed rate as it is for expedited commercial cases, and whatever it might be a daily rate, whatever is promulgated by the rules or understood by the staff is what you will see in that notice of compensation arrangements. There is also, I just took recently, AAA's mandatory training for its arbitrators for 2026. It's called ACE 26, entitled Case Finances, Key Guidance for Arbitrators. I have to say, I think it's one of the best mandatory CLEs that I've ever taken with AAA. It's very well presented, very clear, and they give you a lot of resources that are on which the conclusions are relied on. And there's some surprising learning in that training. So I highly recommend, if you're a AAA arbitrator, if you haven't taken this annual course yet, do it as soon as possible. It's really going to affect your billing practices. There is a FINRA arbitrator's guide that applies to all FINRA arbitrators, regardless of the nature of the case they're working on. FINRA Code of Arbitration Procedure for Customer Disputes. Those are arbitrations between the investment bank or financial institution and its customer, typically broker-dealers and their customers. And there's the FINRA Code of Arbitration Procedure for Industry Disputes. Those rules govern the disputes arbitration between investment banks, financial institutions on one hand, and typically their employees or their registered representatives, financial advisors and so forth that work for that institution. That's on the arbitration platform side of the requirement authorities. Then on the lawyer's side of the requirement authorities, of course, is the ABA Model Rules of Professional Conduct that are the model for the rules of professional conduct adopted by most jurisdictions in the United States of America and apply to lawyers licensed to practice law in the respective jurisdictions. And they differ in some nuances from state to state. The rules we're going to talk about today are very similar, if not identical, in most states, but there are other rules of professional conduct that have a lot of nuance to them, particularly one of the areas, which is billing, the Rule 1.5, which is the rule that governs how you bill and the manner at which you present your billings and so forth. That can vary in detail from state to state. Of course, as I mentioned earlier, the authority also includes individual agreements among the parties to each arbitration case that provides the jurisdiction, may also provide ethics rules that apply to that case. And then, of course, applicable law. state law or other territory law that will apply in the respective jurisdiction. Of course, we can't address in this very short presentation the multivarious ethical requirements imposed by those agreements or laws and rules of professional conduct in various specific states, but we are going to focus on certain critical arbitrators' ethics topics addressed by the promulgations of AAA, FINRA, and ABA's model rules. The first, of course, I'm sure you're all aware, maybe the most important, arguably, of all ethical requirements are those that relate to conflicts of interest. When you do your training as an arbitrator, you get a lot of drilling and grilling, and all the forms you get when you're invited to serve as an arbitrator always refer to the reminder that you must, as I used to hear as a securities lawyer when I was a young associate doing prospectuses, disclose, disclose, disclose. You can never disclose enough. Canons 1 and 2 of the Code of Ethics requires all arbitrators to make pre-appointment disclosures, including continuing disclosures during the arbitration case. And those disclosures must be made not only to the platform staff, but also to all the parties and the other arbitrators. Those disclosures have to include, except to the extent that the parties have consented to a particular circumstance after full disclosure of the relevant facts, the arbitrator must also avoid during and for a reasonable period after a decision is rendered in a case, entering into any circumstance that might reasonably affect that arbitrator's neutrality, impartiality, independence from parties, lawyers or representatives, or potential witnesses, and other arbitrators serving on the same case. For example, if you've been appointed to serve on a case with an arbitrator whom you've served on a panel on another platform, you're appointed to a FINRA 3 arbitrator panel, and FINRA staff doesn't know who you served with when you were doing an arbitration for AAA, and it turns out one of the other arbitrators on the FINRA panel is someone with whom you were on a panel for AAA. Well, of course you must disclose that. Disclosure doesn't necessarily mean that you're going to be recused or disqualified, but the parties and the staff of the platform and all their lawyers, of course, are entitled to know about every relationship that you have that could remotely affect your impartiality and your independence. And again, this is independence and impartiality. It's in the eye of the beholder, not your eye. So if any party or the party's lawyer, and you know how aggressive some of these trial lawyers can be, they see things that no one else sees. If anyone would think that any relationship that you have might have a negative impact on your impartiality, you must disclose it, because the risk is that the case, your decision may be vacated if it's discovered, if the relationship is discovered after the decision is made and you have not disclosed it. You have to obviously have to disclose issues that relate to your competence to serve. Many people serving as arbitrators on various platforms are doing this as a second or third career. We're getting a little long in the tooth, as the saying goes. I monitor myself every time I accept an invitation to serve as an arbitrator. Ask myself, I look at the complexity of the case, I look at the time involved, the pressure involved, the resources that are required, and I ask myself before I accept that case, can you do this, Karen? Can you still do this? You're not 30 years old anymore. Can you still do this? And you need to be very conscious of that when you take on. It's a very large responsibility serving as an arbitrator, very similar to serving as a judge. So you keep that in mind. You also have to disclose your availability to commence the arbitration in accordance with the requirements of the proceeding, obviously to commence, and thereafter to devote the time and attention to its completion that the parties are reasonably entitled to expect. I have been, made commitments to cases that I thought would be over in 6 months and have ended up lasting a year and a half or 2 years. And at the 2-year mark or so, I have found that I've had circumstances that have risen since the beginning of the case that make it difficult for me to be as responsive to the parties as in terms of scheduling last minute hearings and that kind of thing that I would have been if that had happened within the first 6 months of the case. And I have had to recuse myself at that point, because if you can't do it, you can't do it. There's no point in saying that you can and not do it, and then you're not adhering to the rights of the parties and their representatives, as well as, of course, the staff of the platform that works very hard to make these cases go forward. Uh, Unless there is no doubt that the individual is intended to serve as a neutral, uh, then you have to make sure that you are in fact neutral. You have to make sure that your circumstances are such that you're serving in that capacity. The circumstances that require disclosure include these. Again, this is under these requirements are under the canons, under the code of ethics. We're not even getting into the rules of professional conduct yet. These rules, disclosure rules, apply to all arbitrators. The circumstances include any known or existing past financial, business, professional, or personal relationship, or financial or personal interest in the outcome of the arbitration, including, among other personal interests, any outside pressure, public clamor, fear of criticism, and any relationship or interest involving the arbitrators' families, household members, or their current employers. You may have, or their partners or professional or business associates that could be ascertained by the arbitrator's reasonable efforts. For example, if your child's spouse is engaged in a profession that doing work for certain companies that might result in a potential conflict of interest on a case that you might be assigned to, it's your duty to inquire of that spouse who that spouse is consulting to that month. And if the spouse doesn't tell you, then there's nothing you can do about that. But you have to everything that you have to ask. You're expected to ask and disclose whatever it is you learn, and to disclose that you don't know if you don't know, if there's a chance that the person may be consulting to a company that's actually a party to your case. But again, you're only required to exert reasonable efforts in that regard. You're not required to hire a former member of the FBI or another private investigator to do it. Prospective arbitrators should, but are not expressly required, to make a reasonable effort to inform themselves of those circumstances, as I said. The comment to Canon 1 states a prospective arbitrator is not necessarily partial or prejudiced by having acquired knowledge of the parties, the applicable law, or the custom and practices of the business involved. For example, I know that Linda does construction arbitration. One of the reasons she does construction arbitration, and she's been doing it for many years, is that she's familiar with the field. She presumably knows a lot of the people who work, of the companies that work in the field, and many of their management and operations people, and the companies certainly. And that certainly doesn't disqualify her, that fact alone. That in fact makes her valuable as an arbitrator. So that kind of general knowledge of a field and of people in the field is not a disqualifying factor, but specific knowledge that would be related to the case would be something that would have to be disclosed. Same is true for specialized experience or expertise in the area of business, commerce, and technology that are involved in the arbitration. Even if the arbitrator has views on certain general issues likely to arise in the arbitration, but an arbitrator may not have prejudged any of the specific factual or legal determination to be addressed during the arbitration. At the end of my presentation, I'm going to do a case study with you that specifically raises that issue. And we're going to talk about what your views are on what the arbitrator should do in that case study scenario. AAA's commercial rules R18 and notice of compensation arrangements include some, but not all of this requirement from the Code of Ethics. There's another authority is standard and responsibilities address specific competence and availability disclosure requirements related to any personal, physical, or mental condition that may impair an arbitrator's ability to execute responsibility fully throughout the phases of the case. I alluded to that earlier. FINRA Customer Code Rule 12405 and FINRA Industry Code Rule 13408 expand this disclosure requirement to encompass direct or indirect interest. So the Code of Ethics doesn't really say direct or indirect. It just mentions interest. But if you go to the actual FINRA rule, they're looking for direct and indirect interests and relationships, family, social, or other relationships, and existing or past service as a mediator for any of the parties to the instant arbitration case. Now, turning to the model rules on this area of conflict of interest, although rules 1.0 and 1.8 of the model rules prohibit a lawyer from knowingly acquiring an ownership, possessory, security, or other pecuniary interest adverse to a client, unless, among other conditions, the client gives consent that is informed and confirmed in writing. So the words say client. It is reasonable to expect, and there have been some mutterings, on disciplinary committees in various states to the effect that a lawyer disciplinary committee will extend the applicability of those rules to a conflict of interest between a lawyer arbitrator and a party to that arbitration, even though that party is not a client of the lawyer. Now, the ABA Standing Committee on Ethics and Professional Responsibility Formal Opinion 518, dated October 15, 2025, with which I know Linda is very familiar because it has very draconian implications for mediators in particular. But that formal opinion expressly states that at least the drafters of that opinion do not believe that the rules of professional conduct that talk about lawyer-client relationships apply to arbitrator party relationships. But again, that formal opinion 518 does not bind a disciplinary committee. So you want to be, to all extents that you are able to do it, you want to be on the right side of this issue, because it could cost you a lot of time and money to defend a challenge by the disciplinary committee on conflicts of interest basis in particular, which is something that they spend a lot of time worrying about. If the model rules apply, however, if 1.0 and 1.8 do apply, then each party must consent to that conflict of interest after the lawyer arbitrator has communicated adequate information and explanation about the material. I'm looking at the time. Yeah, about the material risks and reasonably available alternatives to that circumstance, and that communication must that consent to that conflict of interest must be in writing by each party, or a writing that the lawyer arbitrator promptly transmits to that party, confirming that party's oral informed consent added within a reasonable time after that oral consent. For this purpose, a writing is very flexibly defined. It can be a tangible or electronic record, including an email, obviously, including handwriting, typewriting, printing, photostating, photography, audio or video recording, and electronic communications. And reasonable denotes the conduct of a reasonably prudent and competent lawyer, not the reasonable man, the reasonable ordinary person standard that you see in other contexts. So you have a slightly different or slightly higher or lower, depending upon how you look at it, level of analysis of what is reasonable under these circumstances. Comment 4 to Rule 2.4 of the model rules, entitled Lawyers Serving as a Third Party Neutral. Again, this is part of the model rules that specifically apply to lawyers that serve as arbitrators. A lawyer who serves as a third party neutral subsequently may be asked to serve as a lawyer representing a client in the same matter. The conflict of interest that arises for both the individual lawyer and the lawyer's law firm are addressed in Rule 1.12 of the model rules. Now, that Rule 1.12, entitled Former Judge, Arbitrator, Mediator, or Other Third Party Neutral, that was just, I mentioned, referenced in Rule 2.4, Comment 4, states, except that an arbitrator selected as a partisan of a party in a multi-member arbitration panel is not prohibited from subsequently representing that party. A lawyer shall not represent anyone in connection with a matter in which the lawyer participated personally and substantially as an arbitrator, mediator, or other third-party neutral, unless all parties to the proceeding give informed consent confirmed in writing. Rule 112b says a lawyer shall not negotiate for employment with any person who is involved as a party or as a lawyer for a party in any matter in which the lawyer is participating personally and substantially as an arbitrator. The rule provides no exception to this prohibition against negotiating for employment for an arbitrator selected as a partisan of a party in a multi-member arbitration panel, except the arbitrator is not prohibited from subsequently representing that party. The rule also does not prohibit another lawyer in a firm with which that lawyer is associated from negotiating for employment with any person who was involved as a party or as a lawyer for a party in any matter in which the first lawyer is participating personally and substantially as an arbitrator, mediator, or other third-party neutral. So there, you do have your colleagues within the law firm are not so prohibited just because you served as an arbitrator. Comment 1 to Rule 1.12 states that the term personally and substantially signifies that an arbitrator who is a member of a multi-member panel and thereafter left service as an arbitrator to practice law is not prohibited from representing a client in a matter pending for mediation or arbitration, even on the same neutral platform, but in which the former arbitrator did not participate. Okay. All right, now that's my presentation on conflicts of interest. I think we have a little more time, so I might be able to get to one or two of the other areas of ethics that are concerning to us. The next one is confidentiality. Canon 1 of the Code of Ethics requires arbitrators to protect confidentiality of documents and other evidence received by them in connection with an arbitration case, even after the respective arbitrator withdraws or otherwise ceases to serve as an arbitrator for that case. Canon 2 of the Code of Ethics requires arbitrators to either secure the consent to any disclosure by the respective arbitrators required by the Code of Ethics of confidential or privileged information from a person who furnished that information to be disclosed, or the holder of the privilege, or if the arbitrator does not secure that consent, the arbitrator must withdraw from the arbitration case. Canon 6 of the Code of Ethics requires arbitrators to refrain from using confidential information acquired during the arbitration proceeding to gain a personal advantage or advantage for others, or to affect adversely the interest of another, to keep confidential all matters relating to the arbitration proceeding, and before it is given to all parties, the arbitration decision and deliberations relating to that decision, and use another person's assistance in connection with reaching that decision only if the respective arbitrators inform the parties of that use and those assistants agree to be bound by this Canon 6 about refraining using confidential information and keeping confidential all matters related to the arbitration. And commercial rule R45 includes some, but not all of this requirement. So again, it's important to remind you must, if you're an arbitrator on any platform, it's important to be familiar with the Code of Ethics, not just the rules of that particular type of case promulgated by that platform. Although Rule 1.6 of the model rules requires a lawyer's revealing information, restricts a lawyer's revealing information relating to the representation of a client, unless the client gives informed consent, except under circumstances stated in that rule, it's reasonable to expect that a lawyer disciplinary committee will extend applicability of that rule to a lawyer arbitrator revealing information relating to an arbitration case for which the lawyer serves as an arbitrator. Of course, to the contrary, again, is Formal Opinion 518, which says that Rule 1.6 applies only to the relationship between lawyers and clients, not to the relationship between an arbitrator and a party. Comment 3 to Rule 1.12 of the model rule states that lawyers who serve as third-party neutrals typically owe the parties to an arbitration proceeding an obligation of confidentiality under law or codes of ethics governing third-party neutrals, and even if they do not have information concerning the parties that is protected under Rule 1.6 of the model rules, if a lawyer is so disqualified from representation as counsel, then under Rule 1.2c, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in the matter unless the disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee from that matter, and written notice is promptly given to the parties and any appropriate tribunal to enable them to ascertain the compliance with the provisions of that Rule 1.12. Under Comment 4 to Rule 1.12, this screening restriction does not prohibit the screen lawyers from receiving a salary or partnership share established by prior independent agreement with his or her law firm, but the disqualified lawyer may not receive compensation that is directly related to the matter in which the lawyer is disqualified. Under Comment 5 to Rule 1.12, the written notice required by Rule 1.12c2, including a description of the screen lawyer's prior representation and of the screening procedures employed, generally should be given as soon as practical after the need for screening becomes apparent. And I think I'm going to try to squeeze in one more ethics area before we get to the case study, and that's communications. Canon 3 of the Code of Ethics prohibits ex parte communications by an arbitrator with any party or that party's representative, except to the extent expressly permitted by Canon 3b, and requires the arbitrator to assure that copies of all communications between that arbitrator and any party or that party's representative are sent to each other party or that party's representative in the arbitration case. Rule 2.4 of the model rules says a third party neutral is anyone providing services to two or more persons who are not clients of the lawyer, to, in other words, an arbitrator or a mediator, for example, or an ombudsman, to reach a resolution of a dispute or other matter that has not arisen between them, as an arbitrator, mediator, or in such other capacity as will enable a lawyer to assist the parties to resolve the matter. A lawyer serving as a third party neutral shall inform unrepresented parties that the lawyer is not representing them. Sounds familiar to Linda and those of you who have read Formal Opinion 518, because this is the focus of that formal opinion I'll get to in just a moment. When the lawyer knows or reasonably knows or reasonably should know that a party does not understand the lawyer's role in the matter, the lawyer shall explain the difference between the lawyer's role as a third party neutral and a lawyer's role as one who represents a client. Comment 3 to Rule 2.4 states, where appropriate, the lawyer should inform unrepresented parties of the important differences between the lawyer's role as a third-party neutral and a lawyer's role as a client representative, including the inapplicability of the attorney-client evidentiary privilege. The extent of disclosure required under this paragraph will depend on the particular parties involved and the subject matter of the proceeding, as well as the particular features of the dispute resolution process selected. Although ABA Standing Committee on Ethics and Professional Responsibility Formal Opinion 518 summarizes and purports to interpret Model Rule 2.4, the scope of the guidance in that formal opinion is limited to lawyer mediators. It doesn't cover arbitrators. Although in arbitration cases, they should have gone on to talk about arbitrators as well, because in arbitration cases in which one or more parties proceeds pro se, a party not represented by a lawyer may assume that the arbitrator seeks to protect that party's interests, especially if the arbitrator provides procedural guidance to that pro se party, and even if the arbitrator adheres to the admonition by the arbitration provider not to provide substantive legal advice to that party. And all of the platforms preclude an arbitrator in a pro se situation from providing substantive legal advice to a pro se party. Just not to go into it in detail because we're lacking a little time, but other areas are fees and billing. You can take a look at Canon 7 of the Code of Ethics regarding integrity and fairness. There's AAA's billing expectations and notice of compensation arrangements that have specific requirements for billing. Rule 1.5 of the model rules sets forth non-exclusive factors, not of all of whom that are relevant in each instance, to be considered in determining the reasonableness of a fee or expense reimbursement requested by a lawyer. And those are not necessarily limited to fees and expenses for legal services. So Rule 1.5 of the model rules, at least arguably, applies to the standards that will be applied in evaluating the reasonableness of fees that you charge as an arbitrator. Just a heads up, AAA staff does not always advise arbitrators that they're billing on an hourly or daily rate cases assigned to particular AAA staff violates its billing requirements before AAA may determine to rotate arbitrators off the roster without prior notice through the respective arbitrators because of alleged violations of billing expectations. So even if you're submitting your bills in timely and in the format required and including all the information that is required, AAA may, and even if you never receive any indication during the course of a case from a AAA staff member that your billing is excessive in amount and that the parties have complained about the amount of the billing, in retrospect, AAA may decide, your billing and the aggregate on these kinds of cases is higher than the aggregate billing by other arbitrators on similar cases. AAA is not going to get into the weeds to look at the particular circumstances of the case, and they may just throw the arbitrator off the roster. So just beware. Okay. Other areas to be concerned about, obviously, is advertising. and you want to be concerned. There's no specific restriction on advertising or substance of advertising in any of the arbitration platforms codes of ethics or guidelines, but Rule 7.1 of the model rules expressly prohibits false and misleading communications and even misleading truthful statements, creating unjustifiable expectations, unsubstantiating claims, unreasonable expectations of what you can do and how your fees and your success rate compares to that of other arbitrators. That is something prohibited to lawyers who serve as arbitrators. That is not expressly prohibited, surprisingly, by any of the non-lawyer promulgations of ethics from any of the platforms, FINRA or AAA. I can't speak to JAMS because I'm not familiar with JAMS rules. And finally, 8.4 of the model rules prohibits, among other actions, any lawyers engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, prejudicial to the administration of justice, or constituting a criminal act that reflects adversely on the lawyer's trustworthiness or fitness as a lawyer in other respects, even when not practicing law. Even if you're going to buy a drink at Starbucks, if you engage in conduct that reflects adversely on your trustworthiness or fitness as a lawyer, you could be disciplined for violation of Rule 8.4. Again, none of the neither FINRA nor AAA's promulgations expressly address that issue, although presumably if one of the arbitrators were convicted of a crime of moral turpitude, you would hear from the platform. But there's actually nothing expressly stated in any of the ethics rules that prohibit that. Now we'll get to we got about 15 minutes left, so this is good. I'll get to now the case study, unless some of you would like to ask questions before I get to the case study. Why don't I take one or two questions if you have any, and then proceed to the case study. No. Okay, hearing none. So let's hear the case study, because case study is interesting and not unusual. An arbitrator is appointed as sole arbitrator in each of 3 personal injury arbitration cases and is considering accepting appointment as sole arbitrator in a 4th personal injury arbitration case, all against the same rideshare company, by different passengers in different vehicles driven by different drivers at the times of the respective accidents involved in those vehicles, all in New York City. None of those drivers owned the respective vehicles at the times of the respective accidents. All of those drivers used the website and platform of that rideshare company, the same rideshare company, to book the trip transporting the respective passengers. All of the passengers used that website and platform to book their trips with the respective drivers through that rideshare company. In each arbitration case, the passenger, by booking the trip using that website and platform, acknowledged, or some people call them apps, whichever language you feel more comfortable with, essentially a website and a platform. Those passengers acknowledge that the passenger's agreement to binding arbitration of any dispute related to that trip through an arbitration provider that was specified in that agreement. I'm not going to tell you who it is, but you can probably guess. In most of these rideshare cases, it's one platform in particular that's generally chosen as the platform. No passenger in any of those cases disputed the jurisdiction of that arbitration provider for a case to decide the personal injury dispute. That agreement between each passenger and the rideshare company also provided in several places that drivers using the website and platform of that rideshare company are independent contractors and not employees of that rideshare company. Other documents in the record of each arbitration case state that the rideshare company expressly did not have control over certain aspects of those drivers' conduct or vehicles used by those drivers when using that website and platform. That agreement and those documents are substantially identical in all 4 personal injury cases. The 3 to which the arbitrator was already appointed, and the 4th to which the arbitrator is considering accepting appointment. In each case to which the arbitrator was appointed, counsel for the rideshare company moved, so there are 3 cases that are pending. Counsel for the rideshare company moved to dismiss the respective arbitration claim on the grounds of no respondent superior or vicarious liability for the negligence, if any, of the respective driver, alleging that the driver at the time of the accident was an independent contractor and not an employee of the rideshare company under the definitions of those terms set forth in opinions of the highest court of New York State, which is we call the Court of Appeals in New York, none of which involved as a party the rideshare company involved in the cases to which the arbitrator was or is considering whether to be appointed. But they all involved rideshare companies that did similar kinds of activities to the rideshare companies that are involved as parties in each of these three pending and fourth prospective arbitration cases. Booking companies, they're sometimes referred to. The arbitrator granted that motion to dismiss in two cases. So we run to the motion by the rideshare company to dismiss all claims against it by the passenger in his car on two bases. On the basis that there was no respondent superior and that the driver was an independent contractor and not an employee. A preliminary hearing on the motion to dismiss in the third case is pending. Because the parties in the three pending cases disclosed to the arbitrator, because this is what you're about to hear, or it's a disclosure that the parties make of information that the arbitrator ordinarily would not have access to, but for the fact that the parties provided this information to the arbitrator. Because the parties in the three pending cases disclosed to the arbitrator numerous arbitrators' orders on motions to dismiss in other arbitration cases in which relief is sought by a passenger against the same rideshare company, the arbitrator is aware that after some other arbitrators granted motions to dismiss in favor of that rideshare company in one or more cases, those arbitrators were recused in one or more subsequent cases in which relief was sought by a passenger against the same rideshare company. The arbitrator has not been advised that any party to the third case, on which the arbitrator has not yet ruled on a motion to dismiss, but on which a motion to dismiss is pending. The arbitrator has not been advised that any party to that third case has requested recusal of the arbitrator in that case. The arbitrator believes that in a future arbitration personal injury case by a passenger against a rideshare company arising from a vehicle accident during a trip booked through that rideshare company, and in connection with which the agreement between the passenger and the rideshare company and other documents in the record of that future case are substantially similar to those agreements and other documents involved in the cases in which the arbitrator granted motions to dismiss. If the arbitrator is appointed as arbitrator in that future case, the arbitrator believes the arbitrator is more likely than not to grant a motion to dismiss by the rideshare company in that future case.